Division 1 is now in session.
Thank you. You may be seated. We are here today on our case number 1 CV160407, Offerman versus GRANADA, LLC. Counsel, each side is allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of it for yourself, because the clock on the podium will reflect the total amount you have remaining, including what you might have decided privately to reserve or publicly. We record these proceedings, so we'd be grateful to you if you'd give us your name and the name of your client when you approach the microphone. We have studied the record in the case. We've reviewed the briefs, and we've also discussed the case at some length in a conference today. So with that, you may proceed.
Thank you. I am Richard Mack for the appellant, Granada. This case is about a lease for a single-family residence in Scottsdale, Arizona. We're interpreting a written instrument, so review here is de novo. The lease at issue is 8 pages long. The operative language here for us is only 15 lines of that lease. That's what Mr. Offerman admits. The 15 lines address this supposed option agreement. So that language is, in fact, dispositive. The other thing is that the lease specifically contemplates future conferences to clarify and negotiate and deal with the additional terms. The lease says terms and conditions of the ultimate purchase to be stipulated by both parties at such time. So at the time,
aside from the price, what are the 3 most significant terms and conditions that, in your view, needed to be filled in?
timing for close of escrow, is it going to close in 2014 or 2025? How payment, and there's cases that say timing of the payment is an essential term that must be in the lease, and I'll get to those. Payment going to be by way of cash or by way of installment payments, and is the existing mortgage to be paid off or not? It's silent on all 3 of those, and there are literally dozens others that the court below inferred. And you're segued right into my argument, if I may. I've got 5 points I want to make. Number 1, this is a statute of frauds case. Statute of frauds governs. Number 2, it's an option agreement, so it's strictly construed. Number 3, the memorandum, the writing, is deficient under either analysis, and there are really 2 lines of cases which I'll address. Number 4, the court accepted parole evidence and created at least 24 additional terms, several of which directly conflict with the language in that 15 lines of the lease. So it's not something where they were clarifying a term or adding terms. They conflict with terms agreed upon. And finally, the language I just quoted about further negotiations to be required is an agreement to agree. And since 1925, our courts have said those sort of agreements are not enforceable because they clearly contemplate future conferences, future negotiations, and an ultimate contract. So with that said, if I may kind of dive in. Larry and I have been doing this together for a long time. In this case and others, we agree on a few things. Statute of frauds governs. We agree on that. That part's simple. What's that?
We'll ask him.
This is a real property contract. 441016 says it has to be in writing, signed by the party to be charged, and the memo must be sufficient. The second piece that I think is fairly easy is option contracts are strictly construed. The third piece.
Counsel, I've read a number of cases that say that, but in each case, I've yet to find one, maybe you can point one out to me, where it was actually determining the enforceability of the contract like we have here.
As opposed to how to exercise it.
As opposed, yes.
I agree with that comment. If you look at the Christmas case, Christmas versus Turkin, it makes a passing reference to it, but I agree. The Western Chance, no, not the Western Chance case, the Kentucky Fried Chicken case and another one talk about strict construction in terms of how you exercise the option. I acknowledge that, Your Honor.
And as a practical matter, would you agree with me that, generally speaking, option agreements, almost by necessity, are going to be much shorter, have some degree of brevity than a typical purchase contract for the sale of land?
No, Your Honor, I don't. The law is real clear that you have to agree to what the terms and conditions are going to be when you finally exercise the option, and that's what the case is.
Down to what level? Like prorating of taxes, prorating of HOA fees?
If you read the cases and the statute of frauds cases, yes, sir. Yeah, that's what they say, and I'll get to
Well,
that.
under what are you saying? Those are all term and manner of payment? I mean, because I read the case law to suggest essentially 4 things that need to be in a contract. Maybe not an option contract, but at least in a basic contract. I've yet to find a case that says these are the things you have to have in an option contract. Maybe you have found one, but essentially you have to know who the parties are, what the price is, and what property is being sold, or what the option covers, and then the terms of price.
The time and manner of payment.
Yeah.
So even under that analysis, time and manner must be required.
What case
I'm going to
says
answer
that?
that as a. I'm sorry. Can I get?
What
I'll
case
listen
says
to
that?
the time and manner case.
Yeah. What case says those 4 terms are required in a statute of frauds?
You have to patch a whole lot of them together. If you look at the T.D. Dennis case,
Okay, go ahead.
if you look at the Western Chance case, if you look at the Register decision, the Custis decision, the Durham decision, and Del Rio and Gray. And
Counsel,
let me
I'm gonna
jump right
ask
into
you
the statute
to
of
provide
frauds.
that to us in writing. I just can't keep up with
Sure.
you. Okay.
They're, and I've got the sites if you'd like them,
that
No,
would be
we could-
great.
but let me, if I,
I've got
you have another question.
questions.
Sure.
Okay. When we talk about the time and the manner, this does have a time implicit, which is the 24 months at the end of that. Mr. Offerman would have the opportunity to exercise the option. And it's called an option, not a first right of refusal. So if we accept that 24 months is when he has to act, wouldn't a reasonable period of time suffice under terms of contract?
The courts specifically say that time and manner are required. If you look at the Roberts Mining decision, that case specifically says close of escrow date is a material term that must be in the writing. So we have a contract, and then you have to go through the escrow process to actually close the contract, and that's where the contract's silent.
So if we're talking about an option contract, which are entered into all of the time, which is I have an interest in your property and we move forward to the point where you have to exercise that option, wouldn't a purchase contract be required in the majority of those transactions?
Yes, and if you do the option properly, you have the purchase contract drafted at the time of the option and say, I, buyer, have the option to purchase under these terms at the specified time if I so choose. That's the strict construction piece.
And if we just look at this without specific performance being the limiting option, isn't it your client that drafted this option contract?
That is true.
And isn't it your client that set up the terms and conditions?
With Mr. Offerman being present and agreeing to them, yes, ma'am.
And when it says terms and condition to be stipulated by both parties, wasn't your client aware of the effect of that language?
I'm not sure that's in the record, but I think I can stipulate that both parties agreed that there was going to be a contract negotiated and signed later if they agreed to terms.
And when we talk about negotiating and sign, what I'm talking to you about is we have purchase price, we have time period, we have agreement to sell, and we have consideration in the form of the $200 payments. This is what we have.
That's
What is it missing?
missing the time of payment, the manner of payment, whether the existing mortgage is paid, what the title company is going to be. Picking the title company, there's a litany of cases under the Real Estate Settlement Procedures Act about which party may choose a title company. That's a real and true issue. What we're going to do about inspection rights, that's one of the things that was conflicting here. The lease says no inspection. The amended judgment created an inspection right. Is the property going to be taken as is or not? The lease says as is. The judgment says the buyer may cancel if he so chooses, if the repairs are more than $5,000. Proration of taxes, just on, and there are literally dozens of things that are real issues that are thousands of dollars that were never agreed to,
When we
not
look
even
at
addressed.
the minute entry, before the specific minute entry, the court took additional testimony and actually came up with the additional terms that you've just set forth. The initial minute entry where she said, yes, specific performance, if she had stopped there, would you have an issue?
Yes, there weren't enough terms there to close the transaction. Yes, ma'am.
And it doesn't appear that you're challenging necessarily the second where she delineates each of the additional terms. We don't even have a transcript from that hearing.
We filed a motion for new trial addressing all of those issues, saying, Your Honor, you can't take parole evidence, you can't create terms. That Holloway decision you're relying upon is not the law of the state of Arizona. And let me jump back to one other piece. The option agreements. Option agreements governed by statute frauds, statute fraud cases, the cases I went through, those Supreme Court cases beginning with Register, Curtis, Durham, the restatement, Court of Appeals cases, Del Rio and Gray, all say that the memo must contain all of the parties' promises, not some, all.
When you're speaking of the whether the mortgage is to be paid as an unstated term, do you mean whether the seller is to convey clear title?
Yes, ma'am.
Okay.
That's not in the document either. So under those Supreme Court cases, restatement, Court of Appeals, there's 7 of them total. Those cases say that all terms must be in the memo. There's another line of cases, there are 2 of them. The clear majority is all terms must be in the memo. So to answer your question with a long-winded answer, all of them must be in the memo. There are 2 cases, T.D. Dennis and Western Chance, that say just the essential terms must be in the memo. And there they talk about the essential terms being time of payment. Here we're silent on that. Manner of payment, we're silent on that. And is the underlying mortgage going to be paid off? Silent on that as well. So under either analysis, the majority Supreme Court analysis, the memo is deficient. Under the outlier analysis, and there's really not a whole lot of discussion in those cases. Those 2 cases, they're pretty perfunctory. But even under those, they talk about what the essential terms, and the essential terms here are missing as well. And if I may, yes, sir.
Yeah, can you go to the Holloway case for just a second?
Yes, of course.
Turn your attention to the quote, or I'll quote the sentence that causes me some trouble reconciling with what you're arguing here, is that it says the determination of the surrounding facts and circumstances, consideration of which is necessary to determine ambiguities in a contract such as this option agreement, is for a trier of the facts, and its determination will not ordinarily be disturbed by this court. So the court's saying there's ambiguities in the contract, like there was there as to property. We're going to determine that by going to a trier of fact. How is that different?
Sure. Very specific case. And remember, in that case, there's an option agreement, there's amendments to the option agreement, there's a note, and there's a deed of trust. The property description was the only thing at issue, and the court said, look, we've generally identified the property. The legal description itself isn't there, but we've generally identified it. The court said we can go to the public record to find the legal description for the property to secure the deed of trust. So they went to the public record and clarified a single term. They clarified a general description going to the specific legal description. Here, nothing was clarified. There was nothing ambiguous. There were 24 plus terms created, and they were created without reference to any public record. So this is not a clarification issue. It's an adding new terms issue. And the court added those new terms even though there's integration provision in the contract itself. The lease says this is the only written document we have. One more piece about Holloway. For whatever reason, the seller in Holloway did not raise the statute of frauds as a defense. So that entire analysis they went through in the Supreme Court and the restatement and all that stuff where they say you have to have all material terms wasn't even addressed. But even setting that aside, the court cleared up or cleaned up one issue, and that was taking a general description of a property and inserting the legal description because we knew, the parties knew what it was. That's not our case. That's just completely different than our case.
Is there's the minute entry, the under advisement ruling in the middle of the summer, and then there's the judgment that follows several months later. Is it correct that your client, that the significance of the judgment vis-a-vis your client is that it shows all of the unstated terms, all of the terms that were omitted in the option agreement because the court had to come back and do it. But I don't understand in your briefing to be objecting to any of those terms if indeed the option agreement is to be enforced.
Yes, Your Honor, we do. The court judicially created an agreement by and between the parties, and our position before the trial was there's not definiteness, it's an indefinite contract. On our point in the motion for new trial, and our point here is every step of the way, the court may not judicially draft terms for a party. They can interpret, and they might be able to, even under the liberal interpretation of the parole evidence rule, they can clarify some ambiguous terms, but that's not what we have here.
I'm just saying that we don't know what the evidence was at that hearing. So we've got no way of saying of determining whether the court erred based on, parole evidence or agreements that may have been struck as to any of those. I mean, separate and apart from the issue about whether the option agreement will be specifically enforced, we don't have any way to review the specific terms.
Right, but again, review here is de novo. The only thing at issue is the 15 lines in that lease and whatever evidence they can bring to support that or not. But regardless of testimony, with all due respect, this is a very finite issue, and there are multiple terms left out of that. Let me deal with one more case because I want to reserve a few minutes, if I may. The agreement to agree idea. Case law is clear that if the parties contemplate future agreements, if they contemplate future negotiations to resolve and draft and ultimately sign if they can, the case law is full of citations that say those aren't contracts that are enforceable at all. In fact, they're at best agreements to agree because the minds haven't met and may never meet. So to address your option question, yeah, you need to draft the entire thing at the time of the option because otherwise people don't know what they're executing. So the common practice is, and the legal way to do it was, you have an option. I'm going to buy the property at a certain time if I so choose, but all the terms and conditions have to be specified for it to be enforceable. That's what those cases stand for. If you look at the Christmas case, it's almost our facts. It's almost identical where the lease says the parties will agree to the remaining terms and conditions by March 31st, 1985. And the court there, Division 2, said that is an agreement to agree. They cite the same cases I do, Cypher Chew, Holmes, and say those are not enforceable because the minds may never meet. So our position is, again, statute of frauds govern under the best line of cases with the statute.
Interrupt you because we're
Yes,
running
ma'am.
out of time, but I've got two questions for you. One, Christmas basically said we've identified that there was an option, but the breach, which was the full payment, was part of the issue. Can you address that small factor?
Sure, and that was kind of one of the issues we have here. How is Mr. Offerman going to pay? Pay it immediately or on time? And that issue, just like in Christmas, was never resolved. But we cited the Christmas case for the idea that if you're going to have an agreement to agree, the cases say the ultimate contract, the end contract, must be fully agreed upon before the agreement to agree is going to be enforceable. And that kind of makes our point in terms of the manner of payment wasn't specified here.
And if we were to say at the point that the court said, yes, specific performance, and just for the sake of argument, we're not going to address that. Moving forward, why didn't you include any information for this court to review regarding the second set of conditions that the court imposed thereafter?
I'm not sure I'm following the question. My position has always been...
Can't do specific performance. It's not an option. I get that. Let's say we say it is an option and the terms that are in that portion of the contract are going to be specifically enforced.
Okay.
Okay? So for the sake of argument, suppose we're there. Then we have this further step taken by the court where they supplemented all of the additional facts, or not facts, requirements by the parties, correct?
I understand what you're saying. Yes.
We have no information about how the court got there. It could be by agreement. It could be by stipulation. You didn't provide a transcript. You didn't provide much. So I'm a little...
I can assure you there is no agreement, and I can also assure you that I don't have any idea how the court got there either.
Okay. That's what I wanted to know. Thank you.
Good afternoon, Your Honors. May it please the Court, I am Lawrence Lind, and I represent Douglas Offerman, the plaintiff at the trial court and the appellee in this action. The first thing I wanted to talk about was something Judge Brown had raised in questioning the appellant, and that is the standard of review, because I think it really strikes at the heart of many of the defenses being raised in this case. This is a trial to the bench, no findings of fact, no conclusions of law. Rare that they get set aside if there's any reasonable evidence to support the judgment. The Holloway case, which we clearly rely on heavily, and in a minute I'm going to argue why, talks about the standard of review, and Judge Brown read it. It talks about a determination of the surrounding facts and circumstances, consideration of which are necessary to determine ambiguities in a contract such as this option agreement is for the trier of facts, and its determination will not ordinarily be disturbed by this court, meaning the Court of Appeals. That is the standard of review on a trial to the bench in an option contract such as this.
Does the statute of frauds apply to this contract?
The contract's in writing.
Okay, well, I'm just asking yes or no. I mean, it does. And
I would assume so. I've never taken the defense all that seriously, candidly, because it is in writing.
Okay.
I never understood. I understand the argument it's not sufficient, but it is in writing, and it was drafted by the defendant.
Right.
So I just don't understand. But that's a great point, Your Honor. The statute of frauds, it is in writing. Secondly, it debunks the defendant's argument or the appellant's argument about, well, you can't take parole evidence, you can't consider testimony of the parties. And the holding in Holloway and this standard of review is also consistent with determining the intent of the parties, which is a well-grounded legal document.
That cuts to the heart. I think what the biggest problem I'm struggling with is this a Taylor versus State Farm case, or is this because 1 year after Holloway in the Custis decision, which by the way Holloway was not a parole was not a statute of frauds case, correct? I mean, it's not mentioned in there. That being said, so a year later, the Supreme Court says this in the Custis decision, where a written memorandum is deficient for the reason that essential terms are omitted, parole evidence is not admissible to supply these missing terms. Well, how do we reconcile that language right there from the Custis decision with the Holloway case?
This is a purchase option, and the Holloway case is scary similar to this one. It talks specifically about the option contract failing to describe the parcels of land to be mortgaged, security for payment of the notes. It doesn't specify the amount or quantity of land.
Change the facts of the Holloway case to change it to price. Change it to price, and say, and would your analysis, would your conclusion be the same? So say the parties omitted the price, but they discussed it. They discussed it over lunch or over breakfast. Can that be proved up?
Would that be parole evidence that would be admitted? Is that your question, Your Honor?
Yes, absolutely.
I guess I don't know, since price is specifically addressed in our contract. I didn't
But see, but the real estate is, I mean, the legal description is addressed in our contract. What we don't have is, we don't have price, we don't have manner and terms and manner of payment.
Well, we do have terms as to how the price is to be determined.
And given that, we also don't have what kind of title is going to convey. I don't know if there is an encumbrance on this piece of property by seller. So when we talk about the kind of, I'm paying X amount of dollars for a quitclaim deed or a warranty deed, what am I buying here? Do you think that that is a material term that is missing?
I think those are facts and circumstances relating to the ambiguity in the contract that Holloway tells us the courts to hear to make its decision about, and that's why it goes to the trier of fact.
What would be the narrowest contract for the sale of real estate or an option to sell real estate that you think Holloway would apply to? I mean, what do you need under Holloway? I mean, what I hear you saying is Holloway, under Holloway, you can establish the contract.
Well, I think you need something in writing.
Okay.
I think the identity
We're
of the
going to talk about a sale later.
That's what the option says. It says in 2 years, if you want to exercise this option, we're going to agree on an appraiser for a price. That is what it says. And that's why the argument that was raised that Mr. Offerman said, well, yeah, there were things we needed to agree on. Well, of course we did. It was drafted by the defendant that the price was to be agreed upon in 2 years. How would you have a date of sale? The option hasn't even been exercised, and it doesn't ripen for 2 years. So I'm not sure.
You're almost suggesting he had no input into the language of the contract. He signed it.
Well, that dovetails into an argument I very much wanted to make today, is that the defendant acted as my client's realtor. He had.
Why didn't we plead that in the trial court? Why didn't we plead like a good faith and fair dealing? Why didn't you plead, breach of fiduciary duty? Why wasn't any of that explored more thoroughly at the trial court level?
It was all pled and argued, Your Honor. Respectfully, I pled the first of all, Exhibit 1 to the trial court exhibit is the contract with the attachment of the real estate agency agreement, where the defendant agreed to act as my client's realtor, where he agreed to be honest and trustworthy, look out for him, apprise him as to anything that could affect the consideration he's paying, and anything that could affect the seller or lessor's obligation to perform. And I argued about the duty of good faith and fair dealing and the Arizona Administrative Code duties of a realtor and the fact that those apply in this case. And I think the trial court found those important, honestly.
Although I don't see a reference. I may have missed them, but I don't remember seeing a reference in any of the court's orders to those issues, and they weren't in the joint pretrial. I mean, make no mistake, what happened here is unseemly at best. But the question is whether this is enough to support an order for specific performance. That's the question. Mm-hmm. And I don't see any breach of duty addressed by the Superior Court.
Well, I don't know if the judge specifically addressed it in a minute entry or as part of the amended judgment, but certainly the record. I questioned the defendant about his real estate agency, his duties. Did he intend that Mr. Offerman was to be bound by his obligations? Did he intend that Granada was to be bound by its obligations? He answered in the affirmative. I believe I questioned him as to you had a duty to look out for Mr. Offerman as his realtor, things of that nature. So it may not have been in a minute entry, and it may not have been in the amended judgment, but it's certainly a big part of the record.
And a breach of that, just let me understand, the breach of that duty you're saying would give rise to specific performance?
Well, I think that all of the documents in trial exhibit 1 have to be read together, is what I think, and I argue here today. And one of those documents is the real estate agency agreement, where the defendant agreed to look out for my client. And, that's the ultimate, I'm not sure what term I want to use here about this case. We have a defendant, real estate, 30 years experience, acting as my client's realtor, drafting a purchase option, and then coming back 2 years later and saying, oh, it's too vague. And so because of a technicality that he created, he wants out of a contract where he clearly gave my client the option to purchase and the right to exercise that option to purchase. And that's really the bottom line for this case. And that's what the Holloway case and some of these other purchase option cases talk about. They turn on equitable principles. There's a recognition by the Supreme Court that purchase options can almost never include all of the material terms.
And if we take all that, and I might have not conveyed to you, you're asking for specific performance, period.
Yes.
Were you asking for damages on top of that?
We had pled for specific performance, so.
Nothing else. So if you had prevailed on the other claims, how was the court supposed to compensate your client if you failed on the specific performance claims? That's what I'm trying to get at. Does that make sense to you?
Yes, and I don't believe I have a good answer, Your Honor, other than by prevailing on specific performance, my client had got what he bargained for and was probably made whole.
Okay, but had you failed at specific performance, do you think your client was entitled to relief under any other basis, and what relief would he have gained should you have been successful on those claims?
Sure, I think he would have been entitled to relief under other claims. Breach of duty, measure of damages, value of the property at the 2-year mark versus what the what he was. Actually, I'd have to think about it, Your Honor. I honestly haven't considered the question closely, but my off the top of my head answer would be yes. I think he would be entitled to recover under other claims.
And that's what I'm struggling with is the trial court had one option based on your plea for relief. Specific performance or nothing. No damages, nothing else. It was that one issue that was decided, addressed in the trial court. So had you failed on that claim, hypothetically speaking, what was the trial court supposed to do with the remainder of the issues?
I don't know, Your Honor. I honestly haven't considered it in light of how the trial went and what the court's rulings were. So I'm sorry, I don't have a better answer for you today.
Turning back to, I think you said that I thought you said, correct me if I'm wrong, I thought you said that the court found the contract to be ambiguous. I thought the court said the contract was unambiguous.
I think the court found the terms and conditions for the right and the option to purchase the property were clear and unambiguous. Those terms were.
So turning to the as-is clause for a minute, does as-is mean that your client would need to take the property truly as is? I mean, title, condition, etc. So subject to liens?
No, and actually these were matters that were discussed as part of the February 16, 2016 evidentiary hearing, and that's how the judge came to determine more fully what the terms of the judgment should be.
But what does as is mean to you? I mean, that seems pretty clear to me. As is. I mean, I know that there's fraud exceptions and, negligent misrepresentation claims that you can bring in a real estate contract, even if you say as is. But as is means as is. As is means there's no warranties. There's no title insurance. There's no home warranty.
I agree, Your Honor, and I think that condition was modified by the court based upon evidence and documentation it took at that February 16th hearing.
Again, I'm trying to stay within the confines of the four corners of the 15-line document. How do you get to have the court write the contract, rewrite the contract, or add 15 terms and conditions? I'm not understanding the legal theory that allows the court to do that.
Well, I think that the court had ordered specific performance, and the record showed that the defendant was not cooperating in any of the orders initially entered by the court in its minute entry trial ruling, and so the court conducted a second trial almost on the terms of the judgment to be entered, and at that trial there were a number of documents admitted. The intent of the parties was fleshed out, and based upon what it heard, the court entered its amended judgment. Now, that's another issue on standard of review. That hearing and that amended judgment, first of all, it wasn't objected to, the form, by the defendant, and secondly, it's basically part of the trial. And the defendant didn't provide that transcript, and the law says if you don't provide the transcript, the Court of Appeals is just going to assume the evidence is supported.
Here's the thing, though, that I think puzzles me. I think it's one thing to sue for specific performance of the option agreement within the 15 lines, the four corners, and I can imagine an order that the court might have said, we're going to enforce that. Go off and sell the land at that price, at the price to be determined by an appraiser to be mutually agreed upon, and would have left all the other terms unstated because they're not in the agreement. I mean, that would have been one way to go. But then the court went, because that wasn't done. I couldn't, apparently, the deal didn't get done at that point. The court then effectively wrote a contract for the parties. And I don't see any basis in the law for the court to do that.
Your Honor, I believe that we had to file 2 petitions for order to show cause to compel the defendant to comply with the terms of the minute entry that the judge issued following the trial. And it refused to do so, just as it had refused to agree to an appraiser or to do anything else it agreed to do. And the courts, as a result of that, set the hearing and took more evidence. And again, this is just like the argument that the terms, that they're not clear enough. The defendant is trying to rely on a technicality here that it created itself. So a couple other quick points, Your Honor, if I may, or Your Honors. The Holloway case, again, it's parts of it are scary similar. It talks about how the information that the litigant was relying upon to claim it was void for indefiniteness were to be determined by proposed plat or plot to be prepared in the future by the agent of the defendant. This method of determination was understood and agreed to by both parties to the transaction. Same thing here. And the court talks about the well-known maxim of equity, that is certain which can be made certain. There's another Supreme Court case. It's Andrews versus Blake, 205 Arizona 236. It's a 2003 opinion, and it's an option contract. It's an interesting case, and the trial court found in favor of the optionee. Court of Appeals reversed. Supreme Court reversed, stating equitable relief for untimely exercise of the option of purchase is a factual determination, and it sent it back to the trial court, which brings me back to my point that the Supreme Court has recognized these option agreements are almost never fully integrated documents. They always have terms to be agreed upon, and that the court is going to allow the trial court to take evidence, hear that information, and make a decision. And that's what happened here. The restatement says the same thing. Purchase option is warranted to avoid injustice if the offeror induces action or forbearance of a substantial character on the part of the offeree before acceptance, and which does induce such action or forbearance, is binding as an option contract to the extent necessary to avoid injustice.
And that's the $200 a month?
Yes. And the fact that my client wanted to buy the house when he met him, and he wanted to buy a house in that neighborhood, and the defendant said, no, we'll do a 2-year lease, and I'll give you an option to purchase. So my client forbeared from buying another house there, and he gave him the $200 a month towards the purchase price. So, Holloway, this Blake case, the Supreme Court, in my mind, has made relatively clear that it's going to use equitable principles, and it's going to allow the trier of fact to hear these cases and make decisions.
Yeah,
Yes, Your Honor.
just for clarification, you're saying that the equitable principles will be used to construe enforceability of the four corners of the document, or is it more equity comes in when it's in carrying out, like in the Blake case, when you were supposed to mail it by a certain time and maybe it wasn't equitable. I mean, that's not construing the four corners of the document in the Blake case, correct?
I think it's determining what the intent of the parties were with option agreements, which almost by definition are not complete. And that's what happened in this case. It looks like my time is up. I'm certainly glad to keep on talking here.
Thank you. Thanks for your argument.
I have 57 seconds, so I'm going to be really fast. I have 5 points. Mr. Offerman himself is a sophisticated real estate investor. If you look at footnote 1, page 4, he's bought and sold dozens of property. He read and understood the contract. Number 2, this is not a case of ambiguities. This is not a case of a court construing something. This is a case of a court creating judicial terms. Number 3, this whole fiduciary duty bit, that was not pled below. There was no expert testimony, no compliance with ARS 122602. That was not even an issue. And the analysis to the enforceability of a contract is irrelevant anyway. Tort analysis, contract analysis, different issues. Number 4, even the price itself is an agreement to agree. There was no methodology in terms of price. If you look at the document, they had to mutually agree to an appraiser. There's nothing even in there that says, well, if they can't agree to these two appraisers, pick a third. That's not even in there. So the price is still something up in the air. And one more piece, the trial transcript, the addressing the missing terms, pages 70 through 79, it's in our opening brief. That's where Offerman admits none of these things, the title company, free and clear title, method, timing of payment, none of that stuff is addressed. So even using parole evidence, what the trial court below came up with is directly contrary to even Mr. Offerman's evidence. Again, 70 through 79, the trial transcript. Thank you.
Thank you. Thank you to both of you for your briefing and for your argument. We'll take the matter under advisement and issue a decision in due course. Now we'll adjourn.